We are having an oral argument session in the 5th District Court of Appeal remotely. I'm Judge Jim Edwards. I'll be presiding along with Mayor Judge Rand Wallace and Judge John McIver. On the panel, we have one case for this particular time slot. And that's Nolan's Roofing, Inc. as assignee of Donald Grant versus Safe Harbor Insurance Company. And that's case number 22-591. And with that, Mr. Barr, we will turn it over to you.
Good morning, may it please the court. My name is Chad Barr, and I have the privilege of representing Nolan's Roofing in this oral argument today. I would like to reserve 5 minutes of my time for rebuttal. I appreciate you allowing us to appear virtually for this oral argument. I know it's important to both of our clients. We're here today asking the court to reverse the final judgment for several reasons, and let me just apologize. I know the briefs were lengthy. I hate filing long briefs, but there were a lot of issues to be addressed. I'm going to try and just focus in really on the highlights today and some main points. In particular, I want to really focus in on three main points this morning. One, Safe Harbor does not have standing to challenge whether the assignment of benefits is supported by consideration. Two, the assignment of benefits is in fact supported by consideration. And there is evidence by which a jury could find that Safe Harbor breached the insurance contract and that there are damages. So turning to the first point, courts in Florida have consistently held that a non-party to a contract does not have standing to challenge its validity or whether the parties have complied with the contractual obligations. And even more specifically, our Supreme Court held in the Legacy case that a non-party to a contract does not have standing to challenge whether that contract is supported by consideration. That was the only argument that Safe Harbor made below with respect to the assignment of benefits, is that it was not supported by consideration. So the Legacy case was decided in 1994, and that was a case where the insurance company was arguing that a change in a fee contract was not supported by consideration. It was seeking to avoid paying statutory attorney's fees. Ultimately, the Supreme Court stated that it didn't need to decide whether the change in the fee agreement was supported by consideration because, quote, the insurance company was neither a party to the contract nor a third-party beneficiary, so it cannot argue that there was a lack of consideration, end quote.
Mr. Barr, don't we have two contracts in operation here? We have the contract of insurance that was between Mr. Grant and the appellee, and then we have on top of that, we have the assignment of benefits, which is another contract between the Nolan's Roofing and Mr. Grant. So we have two contracts in operation. Is that correct?
We have two parallel operating contracts. Yes, and
the intent of the underlying, the whole reason that we're here, if there was no contract of insurance and there was specifically no contract of insurance to cover the loss to the roof, then there would be no assignment of benefits. Is that correct?
Correct.
Okay. And so the intent would be to cover the insured for the loss to the roof. As the facts stand in this case now, has that in fact been accomplished?
Has the roof been replaced?
No. Well, I think I know the answer to that. There's been money exchanged and coverage provided for damage to the roof, and specifically damage from the hurricane to the roof. There has been money that has exchanged hands between the insured and the insurer, but I believe the facts of this case are none of those funds were ever used to remedy or to repair the roof. Is that correct?
That's what the record evidence demonstrates, yes.
Okay. And so getting back to the assignment of benefits contract, what is it that your client has done to provide services under that assignment of benefits? Is it just purely been thus far the initial estimate or inspection that took place and the filing of the lawsuit that occurred in 2017? What else has been done?
Yeah, that would be the main services provided to date. The issue obviously is it sounds like the issue that you're getting to is is that consideration enough for the assignment of benefits? And I think that it goes directly to what the case law is that consideration is sufficient if there's a promise to do something that someone was not legally obligated to do. And in this case, we have multiple promises being to litigate this claim on behalf of Mr. Grant, which Nolan's Roofing was not obligated to do. And we have the promise to replace the roof if Nolan's Roofing is successful in prosecuting this insurance claim. So, which they're also not legally obligated to do. So what we're dealing with is a situation where, and it kind of dovetails back into what the initial point was that I started with, was that there's no standing by Safe Harbor to challenge whether or not there's sufficient consideration, because really, it's like the saying goes, beauty is in the eye of the beholder. For Safe Harbor to argue that those services and those promises that Nolan's Roofing agreed to provide to Mr. Grant are not beneficial to Mr. Grant.
Mr. Barr,
Yes, Judge.
when you filed your claim, did you provide a copy of the assignment of benefits contract to the insurer?
I do not know, but I will say that that's not an issue in this case. If you're
Whether it's an issue or not wasn't my question. I was wondering if the roofing company provided a copy of the AOB when they file their claim, or do they typically do that?
Do they typically do it? Yeah, I would say they typically do it. I don't
Well,
know.
I guess my next question would be why? If the insurance company doesn't have any standing to challenge the validity of that contract, then why would you have to prove the contract to the insurance company in the first place? Couldn't you
don't have
just
to.
assert, I have an AOB and you're not allowed to challenge it because you don't have standing?
It's the answer is simple, because we're putting them on notice that they have who they have to issue payment to. And it's very much like a notice of lien, where we're telling them that we are the one that has the right to the payment under the benefits. And so we have to put them on notice of that. It doesn't mean that we're proving the existence or the validity of it. We're simply telling them that this exists. And if there's a dispute as to whether that contract exists or not, then that's between, the case law has been the same for 100 years, that the contest of that agreement would be between the parties to the contract.
Well,
And so-
at least in the fifth district, that AOB can be challenged if it doesn't meet the statutory requirements. Why
There's
would
no
that be
statu-
any different?
There's no statutory requirements in this case.
But if the AOB can be challenged for not meeting statutory requirements, if an insurance company has standing to challenge an AOB for not meeting statutory requirements, why would it also not have standing to challenge the validity of that contract, to say its void is not existing for not meeting contractual requirements?
Because you're talking about two different things. So you've
I'm
got
talking
100
about a
years.
void contract or a nullity of contract.
No, not at all. That's not what we're talking about. What we're talking about is a situation where you've got 100 years of case law saying that a non-party can't challenge consideration. All right. And then they're relying on the Kidwell group case. That's the case that you're talking about. In that case, there is a statute that gives certain benefits to the insurance company, benefits of notice, presumption of prejudice if the statute's not complied with. That is what, if we go back and look at that opinion, the court doesn't go back and say, this court didn't go back and say, hey, we're dispensing with 100 years worth of case law. It's saying, no, in this case, there is something that gives the insurance company an interest in this case, which is a statutory right to receive notice, a statutory right to receive various items, to be put on notice of certain things, and a presumption of prejudice, which the service provider has to overcome if they don't comply with the statute. That's what this court found gave the insurance company the right to challenge the validity. So it's really challenging whether or not the statute is complied with. We don't have anything like that in this case. We've got two individuals, both of which are sitting before this court in sworn testimony saying this is an assignment of benefits from Mr. Grant to Nolan's Roofing. There's no dispute of that, and there's no statute that gives the insurance company any right to anything in this case. And do we normally give the assignment of benefits? Yeah, we do, but we don't have to. It would be dumb not to, because that's what's putting the insurance company on notice of who they have to issue payment to. So
what is the time limit, Mr. Barr? What is the time limit on the assignment of benefits, meaning how long does Nolan's Roofing have to exercise their right to pursue recovery based upon the assignment of benefits?
In this particular instance, they promised to pursue the lawsuit, pursue the claim, which they did, and they pursued it almost immediately. So I don't know how long they have to fulfill the obligation, but they've done nothing to indicate that they're not going to. They've
But
done
the
nothing.
loss was in 2015. The hailstorm loss was in 2015. And I believe the record on appeal is that Nolan's pursued legal action by filing in 2017. Is that correct?
Yes, that is correct. So October of 2015 and August of 2017. There's no record because we didn't get to this issue, but we don't know what was going on between August and October.
Well, we do know what went on in October of 2017, which would have been Hurricane Irma, I believe. Is that correct?
Correct.
And then the insurance company paid out on that hurricane claim directly to Mr. Grant in just after 2017, October of 2017, correct?
After this lawsuit was filed is when Nolan's Roofing decided that they were going to replace or pay what they thought the cost to replace the roof would be. So we had already filed our lawsuit, and after that is when the hurricane happened, and then later is when they issued payment for that claim. Judge Wallace, did that answer your question?
Yeah, yes, that did. Yep, thank you.
Okay. And again, it wasn't instantaneous, the filing of the lawsuit, but there's nothing in the record indicating that they weren't going to or that they had waived it. But you have to look at the Kidwell Group case in its context, Judge McCaver, and there's nothing in that case that says that this court was creating an exception to the legacy line of case law. And in fact, the assignment of benefits is supported by consideration if the court is going to find that Safe Harbor avoids the legacy line of cases. The promises, the intent of the parties are all very clear in this case. Judge, is that time the total time, or is that also minused out my rebuttal time? I apologize.
That's your total time. So you've got
Okay.
2.5 minutes of initial time and then 5 minutes rebuttal time.
Understood. Thank you. Thank you.
Sure.
And the third point really I just wanted to touch on before I hand the podium back is that there was sufficient evidence by which a jury could find that Safe Harbor breached the insurance policy. And there's really two sub issues of that, whether there was damage during the policy period and whether or not Nolan's Roofing would be entitled to damages. Obviously, we've got the testimony of Mr. Grant, the affidavit of the expert, and also the correspondence from Safe Harbor noting that there was hail damage to the roof. So whether or not there was damage within the policy period should have gone to a jury. There was no evidence of a policy exclusion. I know they discussed this whole idea of marring, but quite frankly, to me, the discussion of marring just kind of demonstrates how far they're willing to go to avoid the initial claim that was filed. The Ergos case makes it very clear that marring goes to cosmetic defects, not structural defects. And the expert in this case testified that the felt was showing, which would be a structural defect in the roofing shingles. And then as to the damages issue, a reasonable jury could have awarded damages. First, you've got the difference in the deductibles. The deductible for the hailstorm was $1,000 versus the deductible for the hurricane claim. That was $3,000. I think we have to consider the totality of the circumstances and the optics when considering the issue of damages. Second, there's record evidence that the amount that Safe Harbor paid, or questions at least whether the amount that Safe Harbor paid for the hurricane claim was even sufficient to cover the cost of a roof replacement. And third, we have to deal with the fact that Florida law is very clear, and this court has held multiple times that even when there is a breach of contract, the plaintiff is entitled to at least nominal damages. And if there were ever a case for nominal damages, I think that this would be the one. So all things considered, there's certainly competent record evidence by which a jury can find that the roof of the insured property was damaged and no exclusion applies, and that damages would be awarded to Nolan's Roofing. So with that being said, I'll reserve the remaining of my 5 minutes for rebuttal, and thank you.
All right, thank you. Mr. Samus?
May it please the court, Scott Samus for the Appalachia Safe Harbor. Starting with the right to challenge the AOB. Of course, we have this court's opinion in the Kidwell group case. And what's important, I think, from that case is the rule that's announced there. To have standing, a party must demonstrate a direct and articulable interest in the controversy, which will be affected by the outcome of the litigation. It's really hard to think of an example where the determination of whether or not this assignment of benefits takes effect affects my client. If you accept that just from a broader perspective, if you accept that an insurance company can never challenge the validity of an AOB, you create this situation. This is the kind of opinion that appellant is seeking. You have an AOB that is unenforceable for whatever reason, lack of consideration, common law, or the statute. It is worthless at that point. However, you can create value in it by assigning it to somebody else. Oh, and it doesn't matter that it's worthless because the insurance company who's resisting it can't challenge that. Why stop there? Why not form 10 corporations, assign a worthless AOB to 10 different entities? All those entities can sue my client, and my client can't defend itself because of this rule. There really is nothing in the Legacy case. In fact, the Legacy case recognizes exceptions to this rule. It says when it ruled that that there was no standing, it also said that we hold that because there was appropriate consideration for the Legacies and their attorney's fees could modify their attorney's fee award. But there's another sentence that's important too. There are exceptions to this rule, such as if the insurance company had in any way relied on the agreement between the parties. Well, when my client is presented with a claim, and Mr. Grant could own that claim, or Nolan's could own that claim. The reason, and Your Honor made a good point about why do you turn over the thing? Because when my client assesses who gets this money, that document has to be evaluated, and they have to decide, because only one entity can own a claim at a time. It's either Mr. Grant or Nolan's. And that really gets to the heart of this case because of these parallel interests create parallel litigation very often. And in fact, the most recent case that deals with this precise sort of legal landscape is the Salyer decision, where Margie Salyer had signed an AOB where the work hadn't taken place yet. It could be, the consideration was work performed or to be performed in the future. The work had not yet been done. And Margie Salyer sued the insurer, and the AOB holder sued the insurer. And the court said that because there had been no consideration to that point, that Ms. Salyer still owned the claim. Well, if Ms. Salyer owns the claim, then the AOB holder can't hold the claim. And there are 4 cases now that are like that: the Nikon case, Sadiq, the Brown case, and most recently Salyer out of this court. So if you create a rule where the carrier can't challenge it, and Legacy recognizes an exception to that rule, it results in this absurd situation where you can take something that's worthless, run photocopies of it, sell it 10 times, and my client has to defend 10 lawsuits with both hands tied behind its back. That just can't be the law, and it's not the law in view of Kidwell and even Legacy. As far as these cases that are brought by the insureds who have signed AOBs and are arguing, I still own the claim because I haven't gotten anything, they apply here as well. Because
Mr. Stamus, just to backtrack a
Yes.
bit,
Sure.
just on one question, that the Salyer case, I don't see that you cited that case in your brief.
It came out after the briefs, Your Honor. I submitted it as supplemental authority.
Okay, all right.
And in that case, there was parallel litigation. Ms. Salyer filed a lawsuit, and I think it was Massey, the roofer, filed a lawsuit as well. And in that case, essentially, the insurer in that case is, just please tell us, who do we owe the money to? Well, that's the situation here. Had Mr. Grant filed this lawsuit, and you look at Salyer and Brown and Nikon and Sadiq, he owns the claim still, because this assignment of benefits doesn't transfer in any way unless the insurance provider approves the claim. So Mr. Grant could sue my client and say, well, right here it says that I don't have any obligation to Nolan's unless the insurance provider approves the claim. This is entirely parallel to what happened in Brown, where it's services to be provided. The contract will.
Wouldn't that completely obviate what is actually being bargained for in the AOB, though? That they agree to stand in the insured's shoes for the purposes of litigation. There would be no litigation allowed if you hadn't approved the claim, right?
Right,
So-
well.
So the idea to say that there cannot be the AOB until the claim is approved seems kind of circular.
Well, we didn't write the AOB. You know, if they write an AOB that has a condition in it that lets them out, then that's not the insurance company's fault. You know, it's like Brown and Salyer, where they write these AOBs to say work done or to be done. Well, maybe the work will be done 10 years from now. You know, when you write an AOB like that, you have to live with the consequences of it. And the AOB holders in Salyer and Brown and Sadiq and Nikon wrote those kinds of things, and it was not well drafted, and that meant it didn't pass to the other side. I mean, the acceptance of the proposal, Nolan's is authorized to do the work specified upon the approval of my insurance company. Even Mr. Grant testified that was his understanding. Says, I know we stated it, when this is resolved, you're waiting or wanting Nolan's roof to replace your roof, correct? Well, I mean, as long as their pricing is reasonable, I assume their pricing would be reasonable because it would be agreed upon with the insurance company. So the testimony by Mr. Grant is entirely consistent with this AOB that was written by Nolan's. So when my client gets an AOB like this and looks at this case law, what choice do they have? Under the case law as it exists and under the AOB as written by Nolan, Mr. Grant still owns this claim. And the fact that they filed, well, first of all, the inspection was not consideration because it was a sales tactic. They go around the neighborhood and they give free inspections in order to try to sell AOBs, essentially. And we cited the Florida National versus Brown case because there's no prior agreement, it doesn't count as consideration. And then the lawsuit benefits Nolan's. I mean, they could take this lawsuit and win and point to these contingencies that are in the contract and just hold on to the money, and also point to the fact that Mr. Nolan or Mr. Grant has already been paid for a roof. And there was even testimony in the record where Zach Nolan said, well, you know, we can't recover for 2 roofs. Exactly. So if you look at the flip side of this kind of litigation and the cases that have come out, including Salyer, the question then boils down to who owns this claim today? And it is Mr. Grant. The other aspect of this is the lack of a breach. Now, it's important to understand that Mr. Grandinetti is the source of the evidence on breach. He signs an affidavit saying I can, you know, I've evaluated damage. I can tell when damage happened and all those kinds of things. Then he says, here are the pictures that demonstrate that this is a covered claim. It's pictures of pockmarks on a roof. He doesn't talk about, how he can get into his time machine and figure out when those happened or anything like that. But even if you believe all that, which is completely unsupported by his conclusory affidavit, the photographs that he points to are marring. If you read Ergus and you read Gamero, chipped tile floor and dents on a roof from hail, I can't see the difference physically between those two things.
Counsel, was that
Yeah.
something the trial court decided?
No, they didn't get to the question, Your Honor, because it was determined on standing.
And let me ask you this, in terms of standing and lack of consideration, isn't Nolan's promise to pursue the claim sufficient consideration?
It's not, because that benefits only Nolan. Nolan can turn around. Let's say Mr. Grant sues, right? Nolan can recover and then claim, well, Mr. Grant, under this case law, you still own the claim. And, it's too bad that the court ruled for me. And oh, by the way, it says here the contractor will be paid the replacement cost value that the customer and customer's insurance carrier agree upon for the work. Well, the insurance company agreed on zero. So, this is like Brown. The work is specified upon approval of my insurance company. Well, your insurance company didn't approve any work by us. So we don't, that's our money. The AOB says the company that Nolan's can settle or otherwise resolve said cause of action as they see fit, and that the payment is solely and directly to Nolan's Roofing. So it's an article of faith that if they win this lawsuit, that somehow they have an obligation to fix a roof that, by the way, Mr. Grant has already been paid for. So it's hard to see, in view of these cases that say these kinds of AOBs are insufficient to transfer these rights to a vendor or roofer like Nolan, how suing to get money for Nolan's counts as consideration. So for those reasons, Your Honor, unless the panel has more questions, we would ask that the court affirm the summary judgment.
I don't see any questions from my colleagues. So Mr. Barr, we're back to you.
Thank you. I guess what's increasingly frustrating in reviewing this case is that the argument centers around how this affects Safe Harbor. And there's not a single case that says that an insurance company can challenge the validity of a assignment of benefits for any reason. And we only have to look at the McGrath case, which of course we cited in our brief. That was decided by the that was decided by the second DCA in 2005. That case specifically states that an insurance company who is not a party to an assignment of benefits does not have standing to challenge whether the assignment of benefits is supported by consideration. I could take, and that's it. There's no exceptions, there's no nothing. That's what the second DCA said. So to accept Mr. Sambus's argument today, this court would have to certify conflict with the second DCA on that very point of law. This court would have to certify conflict with the centuries worth of case law stating that a non-party to a contract cannot challenge consideration. And Judge McIver, going back to the Kidwell case, that case wasn't about consideration. That case was not about consideration. That case was about whether or not the service provider complied with that statute. This case is only about consideration. So Mr. Sambus spent 10 minutes talking about whether or not this assignment of benefits is valid, when really the question is there consideration?
My question that you're addressing, though, wasn't about, I understand that the difference between the two is that one is challenging consideration to say that the AOB is void, and one was challenging statutory considerations to say that it's void. But at the end of the day, they're both challenging the AOB to say that it's void. So I was asking for you to distinguish that. What is the justified distinguishing factor for that?
The statute gives the insurance company the interest in the Kidwell case. There's no legal interest in this case to challenge the assignment of benefits. That would be the easiest way to cite that, or to note that distinction. So So there's the McGrath opinion that this court would have to deal with in accepting Mr. Samus's argument. They didn't even address it. They didn't bring up legacy in their briefs. They didn't bring up McGrath in their brief. They didn't address it. They just asking this court to create this exemption or this exception from whole cloth. There's no support for it. It can't do it. The Sawyer case, I fail to see how Sawyer bears on this issue whatsoever, because this court in Sawyer was very, very clear that the reason why the insured maintained the standing to bring that case was because the assignment specifically stated that it was for services to be rendered. It carved out what it dealt with, which was services to be rendered. In this case, this assignment of benefits says, I hereby assign and transfer any and all rights, benefits, and causes of action to Nolan's Roofing, period. It doesn't carve out for services to be performed, services that have been performed. It says any and all causes of action. And Mr. Grant said in deposition and said, I want them to handle it. I signed an assignment of benefits so that they will handle this case, and I don't have to. And then Mr. Samus talked about the assignment of benefits only benefits Nolan's Roofing. How? How does it benefit Nolan's Roofing only when Mr. Grant doesn't have to sit at trial? Mr. Grant is not subject to a proposal for settlement. Mr. Grant's not subject to 57-105 that my client is now subject to because of this case. And why does Safe Harbor get to even have that conversation about who benefits? Is the exact reason why an insurance company who's not a party to an assignment of benefits should not be able to challenge whether or not there is consideration. Beauty is in the eye of the beholder. So are the benefits that derive from that assignment of benefits. So in conclusion, the court doesn't have any other questions. We would ask the court to reverse the final judgment and remand this case to the trial court.
Right, seeing no questions from my colleague, we will be in recess. And thank you, well briefed and well argued.
Thank you.
Thank you.